We would have thought that, after every 4 years, when the tribunals are set up, we would get better at them in terms of honing, certain practices that ought to come out of it. But it would seem that the introduction of the card reader has thrown spanners in the works, and so it would seem that we're starting all over again. Do you seem to get that feel?
I believe that the card reader is important for our electoral process in Nigeria. And as a matter of fact, it was introduced in order to curb this idea of electoral malpractices. It is fundamental. Mm-hmm. However, the conflict is still within the context of, I think, Article 22 and 28. Because I think from 21, 22, it is clear that you either use the card reader or the INEC can determine another means, which is probably the manual means of recording, accrediting voters. Then if you go to 28, it says that where vote exceeds the number of persons that have been accredited by the card reader, that election will be nullified and the winner of that election will be nullified. I want to say that in every democratic process, you come up with new things. And sometimes you try your best to look at the pros and the cons. However, it is only when you go into it, you will discover one or two problems. And then you keep moving to correct them. Mm-hmm. I do not want to assume and then make the position that the card reader is not important. But we need the appellate court to decide on that, because if you look across Nigeria, the decisions of the tribunals, more than 75% of those decisions touch on the card reader.
So if that is the case, what are you going to be, well, first of all, we will say that we have not exhausted the courts on, the use of the card reader on this one. But if we're to look ahead and say the next 4 years, perhaps INEC will be looking to introduce something new.
Right.
And perhaps make sure that maybe even the card reader is incorporated into the Electoral Act, right, so as to remove or reduce controversies surrounding it. What would you be saying to INEC in terms of introducing into the laws to ensure that, litigation is straightforward and it is to the point, especially after elections?
Right. I think the point is not to the INEC, as it were, because INEC draw their power from the Electoral Act, but the lawmakers are the ones that make laws. Now, by the time we have lots of problems, and then that provision of the law is seen to be generating more mischief than solution, then definitely before we get to the next election, in 4 years' time, the National Assembly will have to do something about that.
Yeah, but oftentimes, National Assembly does something when it is prodded by INEC. Oftentimes, INEC would just bring in the amendments to the Electoral Act. I hope I'm right on that one.
Yeah, are you suggesting that INEC will send a proposal, so to speak,
perhaps,
to the National Assembly? I think that the process of lawmaking is you get interest articulation from members of the society. The lawyers are going to play a part in it. And I believe that the members of the National Assemblies are also product of the result of election. And they must have, if you look at in 2010 as amended our constitution, most of the amendments that were introduced to cure the defects that we encountered in the past. So the National Assembly, they are in the know. I don't think INEC as a body would necessarily have to take these amendments, proposals to the National Assembly.
When they get to appeal.
Right.
I mean, I've heard different councils say different things, but just why do you think, or why do you think they think that it will go in their favor, especially when they say you can't introduce new materials at appeal?
On appeal. Well, election petition is considered as sui generis. It's a different class of litigation of its own. And we have rules of procedure that guide the conduct of election petition. For example, if you look at the elements you have to establish before you can secure your claim in the tribunal, even though election petition is considered as a civil issue, but you see, because the electoral offenses and some of the allegations you have to prove have criminal coloration, you have to prove the existence of these facts beyond reasonable doubt, which is not what we find in normal civil proceedings. Then you have, there's one other issue in election. Well, in civil proceeding also, he who asserts must prove. So if I assert that XYZ stole my stuff, I will have to prove he stole it, and by proving every element of that. But you see, in election petition, even the respondent is permitted by law, when putting up a defense, to level allegation and go as far as proving it against the petitioner as though he is the petitioner in the matter. It's a sui generis. Then when matters go on appeal, the Electoral Act is clear. What guide the conduct of appeal in determining the matter is the same principle that guide conduct of civil action in the Court of Appeal. I decry the idea of a lawyer or any person, prejudicing the court, given the impression that on appeal you are going to win your case when you've not put up facts. Let me even tell you, some of the people casting aspersion on the judges, you need to look at the documents before the court and how the matters were argued. The judge, the tribunal chairman in Delta State had to rebuke the petitioners in the matter because they had about 7 or 11 A4 paper petition when they had more than 33 local government or thereabout. In order for you to prove the existence of those allegations you're saying, do you mean you capture all of that in 7 A4 paper? Now, if you don't get what you want, you come out to the media, and the judges are not permitted by law, for example, to come to the media and start
Do you think they should have spokespersons who should speak on their behalf?
When they start doing that, then the judiciary will be politicized. I think that lawyers should know how to control their clients. Even when you go to court, you hear the judges say, a lawyer, you have to, talk to your client.
But as it is now...
I'm still trying, sorry, Jimmerlin, I'm still trying to get that of Abia you talked about. Looks like the judgment hasn't been handed down.
Oh, really?
Are you sure of that? Because
no, I read
the last date I had was November 5.
I'm quite sure November 5.
For the governorship, not for the
for
House of
okay.
Assembly or Reps.
Oh, really? I read it in one of these media papers. But I'm not sure.
I don't think so.
So
We'll check on that.
Right.
But I'm just wondering, because if you say if they have spokespersons, it will be politicized. But as it is, there are those who are talking about it being politicized already. They talk about the word we don't like to hear in judiciary, corruption.
Right. If you look at the CJN, I think yesterday or day before, issued a statement, still using his spokesman. The CJN has a spokesman. And then he warned lawyers and political parties, from casting aspersion on, to desist, from casting aspersion.
But for this particular one, pardon me to button again, it's consistent. When they allege that, oh no, they may have been induced financially and that's why judgment is going this way, which is against what they had prayed in court.
Right. Well, I know that by law, if you say something that denigrates someone's personality, it's actionable in law. But you see, the judges...
Even by innuendo.
Yeah, but the judges who preside over the matter, think of a situation if you're presiding over a matter, you just handed out your judgment, and then a politician goes to the media and now says you collected bribe. Do you now go tomorrow and then sue him? That means you're going to find the judges in a situation where they will become litigants rather than others. I think that there should be probably a bar and bench forum where the judges will now advise the lawyers. You see, because what the politician or client goes to the media to say, to a large extent, is determined by the kind of advice his lawyer gives to him. If you tell him the danger of going to cast aspersion on the judge, then he will behave.
Okay, in winding down, what, if you could rate it for us in percentages now, what's the chance of, if one loses his case at the first court of instance, the tribunal, if he goes to the second for the governorship now,
right?
If he goes there at the appeal, he will get it overturned?
Very possible. You see,
in terms of
the law
percentage, 50, 60, 40, 70?
With the decisions that have been handed so far, some of the decisions are tight. In my opinion, I doubt if they would succeed. You see, because if you're a petitioner or you're a respondent, and in that decision the court holds that the petitioner has gone beyond reasonable doubt to establish, for example, every element in that petition, and then you fail to debunk this, some of your witnesses, their character betrayed, their testimony betrayed their character, and the facts are there, and the court arrive at having evaluated the evidence, arrive at a decision. If you go to the Court of Appeal, I know that appeal, you succeed on appeal either on law or mixed law and facts. If the tribunal judge, after evaluating the case, reaches a conclusion that has an error of law, then there is every chance and every possibility that on appeal it will be overturned. If you ask me to give a percentage, I think I would, it's difficult, but I would say the chances of matters succeeding on appeal will be 20-25.
20-25.
Yeah.
That's tough.
On all whether PDP, APC, or any party.
Yeah. All right. I'm afraid we have to go. We will have another one coming very soon. Bola Daniel is an adjunct lecturer, Nigerian Law School, legal practitioner as well. He's also a barrister of Lincoln's Inn in the UK. Thank you for coming on today.
It's my pleasure. Thank you.
And we will be back in a moment. We've got another perspective on the same matter, so don't go away yet.